thing like that happening. And fair market value for your properties is
It's defined as whatever you could sell it for on the open market in an arm's length transaction, but usually determined by a person who does uh, an evaluation. What do you call that? Appraisal, right. So licensed appraiser, but oftentimes, especially like within city limits, they will give it to you on your tax statement, the estimated fair market value, and the IRS and the state usually will accept that, even though it's usually low.
yes.
All the other siblings accept that.
Hey, wait a minute.
Okay. Welcome, everyone. I think we're going to go ahead and get started. And we're glad that you could all make it and hope that you were able to find us okay. I'm Laura. I do intake for our firm, so a lot of times the first person that someone will talk to when they contact us is me. So then I set people up with consultations with Attorney Kraus or Attorney Fensky. Angela's our paralegal. She does wonderful work. Anyway, Dan has years of experience and a wealth of knowledge, and I'm not going to talk any longer. Here's Dan.
Thank you, Laura. Please remember to tip your waitresses. I'll be here all week. My name is Dan Kraus. I'm an estate planning and elder law attorney, and I practice in Wisconsin. I'm also licensed in Illinois and Minnesota, but don't really practice much there. I'm from Wisconsin, central Wisconsin. When I got out of law school, my grandparents said, "Hey, we need some legal help. We want to make sure that we don't lose our little farmstead." It was this 5-acre farmstead, just in case something happens to us, like nursing care. So, just out of law school, I had never taken a class on this. I didn't really know anything, so I read a book and I did some research and I helped my grandparents put together a plan. They were very pleasantly surprised to learn that they had nearly $250,000 worth of assets that they wanted to protect. Now, for a lot of people, that's not a whole lot. But this was back in 1999, 1998, 99, and they were a traditional family. Only my grandfather worked. My grandmother did some substitute teaching now and then, and they lived a simple life, but they wanted to make sure that what they had managed to build over their lifetime could be passed on instead of drained away. So that was one of my first forays into helping people in this area of the law. And since then, I've 25 years, 26 years now, I've got a lot of experience helping people. The laws have changed. Some of the things that I helped my grandparents with and we did for them doesn't work really anymore, but there are other things. So, of the people that do this in this state, there's only 7 specialists, and I'm one of them. Another thing about me and my history is I was in the U.S. Army for 21 years. I took a break for a little while. I was in the Peace Corps, and so I can't be in the Army and the Peace Corps at the same time. People wouldn't know. It seems a little bit psychotic, perhaps. But this is a picture of me in 15 or 16 before I retired with my BCGs on. Is anybody familiar with the BCG term? In the Army, we call these glasses that they give you when you're in the Army, they call them BCGs, and it stands for birth control glasses. Because nobody wants to go on a date with you if you're wearing those glasses. So that is me, a little bit about me. And I have written a book. You may have picked up a copy of the book over there. All the materials here are free except for the book. If you feel free to page through the book while you're sitting here, take a look at it, read a bit of it. If you want to purchase the book, it's just $10, and we can give change if you got cash. I don't think we have the facility to take a credit card today. But that's the book on Wisconsin estate planning. And here's some of the kudos and associations and the reviews that we have as a firm, and some of them personally, organizations that we belong to. So, start out, we're going to look at the tiger in the eye. The tiger is you may end up in long-term care. Now, we don't know who is going to and who's not going to. Some people we can see pretty clearly when they get closer and closer to needing care that they might need this long-term care. But we do know that if you reach the age of 65, you're likely, or about as likely as not, to need some time in a long-term care facility. Maybe a short time and maybe a long time. The average time that people spend in a long-term care facility is somewhat over 2 years now. And as you get older, of course, that probability increases. So, some of the dangers of getting older, and this is looking the tiger in the eye again, is some people end up with debilitating illnesses. Some of these illnesses affect the mental capacity, some of them affect physical capacity, and some of them affect both. But these are the types of things that we can typically see in people that inhabit assisted living and nursing facilities. It's expensive to have long-term care. Long-term care in a nursing facility, typically around here, costs about $156,000 a year, approximately $13,000 a month, and rising steadily and quickly, faster than inflation typically. If, and I've seen people do this, if you want to be cared for at home, you may spend $200,000 or more on doing that kind, getting 3 or 4 nurses on a schedule that will sit with you and stay with you and help you through the day and through the night. Okay, so who pays for that? Not Medicare. Medicare does not pay for long-term care. Medicare will pay for nursing stays only for the purpose of rehabilitation. So that's not considered long-term care because there is a rule, Medicare will not pay for long-term care. So if you've broken something, your leg, etc., and you end up in a nursing home for rehabilitation, Medicare will pay for that stay as long as it doesn't become long-term care. And they reevaluate that every week or so. And they will only pay for up to a maximum of 100 days in their specific requirements. One of the requirements is before you go into a nursing home for Medicare to pay for that stay, you must have stayed in the hospital for 3 nights. Because of this bright line rule, there's many hospitals that work with people and they're like, well, we want to discharge you today, but we'll keep you till tomorrow because we know of this requirement. And you need to go to the nursing facility in order to rehab because you can't go home with that broken leg. So you can have Medicare pay for some things in a nursing home, but it's not long-term care. Health insurance, your normal health insurance that most people have, is not going to pay for long-term care. It's the same as Medicare. The same rules apply. They will not pay. Long-term care insurance, which is a specific type of health insurance, or maybe it's not even considered health insurance, but it is sold separately, and that will pay for long-term care, but sometimes it only pays for a portion. It depends on the policy. There is aid and attendance, which some people may have heard of, is available to veterans and their spouses depending on certain qualifications. That will help a person pay for long-term care, but it's capped at $31,000 a year currently. It goes up by inflation, but it never pays for a full stay at a healthcare facility. Oops, sorry. Medicaid is a very common way to pay for long-term care. In fact, Medicaid is the source for funds to care for half of the people who are in nursing facilities in this country. Licensed nursing facilities, half of all the bills are paid through Medicaid. Imagine the bill. That is why many politicians attack Medicaid because they want that money for their special interests instead of for people that need long-term care. And then out of pocket. So for most people, what that means is you pay until you go broke. And then Medicaid pays. So the story of half of all of nursing costs being paid for by Medicaid means that at least half of the people in nursing homes are broke unless they've done good planning. But that's fairly rare, and that's what I want to change. All right. So I want to talk to you about a basic inequality in the healthcare system because oftentimes people come to me and they say, I understand that you're hiding assets and that you're helping people to keep their millions while they have someone else, the taxpayer, pay for their nursing care. Well, I also want to tell you that I've never helped a person that has $3 million do this. They can pay for their own care and they're not going to really lose much. Okay, so this is not a plan for millionaires. Millionaires never want to be on Medicaid. Okay, that's just something that it doesn't make sense. They want care in their own home. They want to have all kinds of control. They want to be in the facilities that don't even accept Medicaid. We help people that are the standard people that we see have a house, maybe they have some hunting land up north, and then they've got some IRAs and maybe some other investments. But it's not going to be $3 million or more. And if you're the $3 million type, probably don't have a lot of good useful information here today for you. But the discrimination that exists in the healthcare system is something that I am happy and proud to help people to eliminate as much as we can. So let me explain what the discrimination in the healthcare system and why I don't have any ethical qualms about helping people to shift their money around so that it benefits them and their family instead of benefiting the nursing home and the state. So the basic inequality is because of the fact that Medicare pays for inpatient and outpatient care and some drugs depending on your plan. Medicaid pays for long-term care. Now, Medicaid will also pay for these things once you're on it, but only Medicaid will pay for long-term care. We all understand that Medicare is something that people get when they're 65. I hope we all understand that. If you don't, then you're not probably a citizen or a legal resident of this country because then you won't get Medicare. But most people in this country do qualify for Medicare at 65, and then they sign up, and it pays for most of their medical care. Everybody gets it, even the billionaires. So Medicaid, however, is a needs-based system, and nobody gets it automatically. You have to qualify for Medicaid by having little assets. Essentially, you have to go broke before Medicaid pays. So if you think of that, Medicare is for everybody, Medicaid is only when you go broke. That means that there's a basic discrimination in the healthcare law in this country. If you have certain types of disease when you get older, you have to go broke to pay for your care. If you have other types of diseases, the cost might be in the millions, but you don't have to pay. You get insurance and Medicare pays. So, who chooses what type of disease they get? I don't know anybody that has the ability to choose which of these diseases they're going to get. I wouldn't necessarily call anybody who needs a heart transplant lucky, but financially they're a lot luckier than somebody with Alzheimer's disease. Okay? This is the basic inequality that I like to help people with. And the real truth is that nobody's going to talk to you about your options regarding Medicaid. You can qualify for Medicaid if you're willing to bring your family into the discussion and put some of the burden on the children who are going to eventually get all of these assets that you're able to save for them. Your nursing homes will not tell you, your assisted living facilities will not tell you about this, and the state or the county will not tell you about this because it's not to their advantage for people to do this kind of planning. And that also, I think, is the reason why when I talk about this, in the back of their minds, people just can't say, this is going to work. It's a frustration for me because people say, I just don't believe it. Okay? Well, believe it. I'm telling you right now that things can be done. So, the government has a plan for you, and this is the plan that will be told to you by the nursing facility. It will be told to you by the assisted living facility. It will be told to you by the wonderful people at the ADRC, if you're familiar with that, the Aging and Disability Resource Center. When you call them, they'll tell you this is your plan. This is what's got to happen before you can get Medicaid to pay for your care. You have to spend down. Now, certain assets are countable and certain assets are non-countable, and some things are considered to be income. And you have to arrange the assets in these groups before you can decide exactly how much you can keep and how much can be saved. However, this is the basic this is the basic plan. You get to keep $2,000 of countable assets. Usually that's one checking account where your Social Security goes into, or your income. Everything else, well, you can also keep your pots and pans and your furniture, etc. They don't count that. So your normal, everyday type of stuff. Now, if you have a Picasso hanging in your bedroom, that's going to count. But normal, everyday things that you have around the house aren't going to count. Now, your home is not going to count as a countable asset. You can only have one home. Every other piece of real estate is going to count. One car, even if it's a couple, one car is exempted, so you don't have to count that car. Nice, in Wisconsin, there's no top to the value on the car. So you could have your Ferrari or Lamborghini or whatever. People more often have a very expensive van that can lift their chair into the van. All of those things are exempted. And you can have burial insurance or prepaid funerals, etc. Those are all exempted. Everything else pretty much is countable unless it's income. So that's great. A lot of people say, hey, I don't have to worry about losing my home. That's where most of my assets are. Most of my equity are. However, there's another part to this, estate recovery. So the spend down is while you're alive before you can qualify for Medicaid. The estate recovery is after you've received Medicaid and then you die. The state will take your home to pay back Medicaid. They recover what they spent on you. They keep a bill. They present it after death. If you kept your home during your lifetime, you are not so smart about that. So we've talked about the cost of nursing care, about $780,000 for 5 years. Long-term care insurance, a good idea if you can afford it or get it, but it's getting to be a worse and worse bargain. 25 years ago, getting a policy of long-term care insurance was actually pretty affordable, especially compared to today. But what happened about 12 years ago was the Standard & Poor's, which is a company that values large firms like insurance companies. You get a Standard & Poor's and S&P rating on your insurance company, and a very large insurance company called Genworth took a hit. Like they were graded A plus forever, and then they got downgraded to an A or a B plus. And it shook the whole financial world. And the reason they got downgraded was because they did not evaluate the cost that they were going to incur on the back end of these insurance policies, because more and more people are living longer and longer, and the cost of nursing care is going up and up, and they were losing their shirts on these policies. So across the board, universally, every insurance company jacked up their rates and lowered their benefits because insurance companies don't lose, right? Insurance companies don't lose. They will charge more than they pay out or they die. Okay, so let's give just a little illustration of the government's plan. So let's think of dad, okay? Dad has got a $300,000 nest egg. It may be in IRAs, it may just be in other investments, could be some property up north, a cabin or something, plus he's got a home. Let's say the home is also worth about $300,000. That's a $600,000 estate. It's about average, probably right in the middle of where the people that we deal with. Now, dad, unfortunately, has Alzheimer's, but otherwise very healthy. He goes into a nursing home. All that $300,000 is drained out over, let's say, 3 years, 4 years. And then he keeps the home and goes on Medicaid. Unfortunately, after he dies, Medicaid has paid another $300,000 on his behalf. Now they take the home and his kids get nothing. Another bad byproduct here is while dad's in the nursing home after his money's gone, he has no security. I mean, the kids could sell the home, essentially, but if they do, now he goes off of Medicaid and he has to use that money to pay for his care. So he doesn't have any security during his stay in the nursing facility. This is not the plan that I want for people. All right. Elder law in the area of Medicaid planning and law in general is based on knowing the rules. If you know the rules, you can use the rules for the benefit of yourself and your clients, in my case. There are ways to save assets and still access Medicaid to pay for care. I want to emphasize you have to have trusted family members. In a rare case, it might be trusted friend. Okay? But family is family and friends are friends. You have to have somebody that you're willing to turn control of your entire estate or a good portion of it to, that's going to hold it there for you during your lifetime for your security, and then upon your death it just pays out to your beneficiaries. People that do not have a trusted individual, the banks will not do this. Bank trust companies are happy to hold millionaires' assets, but they will not work within the rules to help people save their assets from Medicaid. All right, so a smart plan is not the government's plan. The smart plan is to keep everything in your family. Keep security during your old age, and then give everything to the kids and pass it on to the next generation when you die. So, some concepts that are very important to Medicaid planning, and some of these things are where we know, by knowing the rules, we can use the rules to qualify our clients for Medicaid. Gifting or divestment. In the rules, it's called divestment. It's just getting rid of anything for less than fair market value. So it's either giving it away or it's selling it for like $100. If you sell your house for $100, I had a lot of clients say, "Hey, why don't we just do that? That's not giving it." Well, it is, as far as the state is concerned. Any transfer for less than fair market value is considered a gift. You can have unlimited gifts to a spouse, which doesn't really always help very much because both spouses' assets are counted regarding whether you can qualify for Medicaid. But there are some cases where we can use this gifts to the spouse to help save things. Also, a disabled child you can gift assets to, or you can bring assets to a pooled trust, which is a type of special needs trust that can help support you during your lifetime. So even if you are a millionaire, let's say we got that guy with $3 million and wants to be coy and qualify for Medicaid to pay for his long-term care. He wants to just take his $3 million and put it into one of these pooled trusts. And then the pooled trust can have him get his massages every day. They can buy the big screen TV and whatever electronics he needs, anything for his benefit. Take vacations, cruises, whatever. This can all be paid for out of this pooled trust. However, when he dies, the pooled trust has to go to repay the state. Okay? So it's not a great way to preserve assets for your kids. It is a nice way to make sure that you have security during your lifetime, though, if that's your main concern.
I have a question for you on that.
Yes, sir.
On the 5 years before Medicaid, what are you talking about with the penalty? What's the penalty?
Okay, we're going to get to that. Perfect. Gifting penalty. The penalty for gifting is disqualification for Medicaid benefits for a certain period. Now, people say, oh, if I give my house away, the government's going to come and get it to pay for my care. That's not true. The government will never, they can't. The law does not allow them to grab that asset that you've given to your child. The child can keep it. There's no penalty for the child. The penalty is for you. Now you're stuck without the asset or the means to pay for your care, but because you got a penalty. So, the penalty is you don't get Medicaid for a certain period. How do you calculate that? First, it's really important to understand when that penalty starts. The government will not allow the penalty to start until you otherwise qualify for Medicaid. So that means you can't just give your house away and then start counting the penalty. You have to get down to $2,000 before you can qualify for Medicaid, and they will start the penalty period. It used to be that you could give away the penalty divisor. At this time, I think it was around $6,000 before they changed the rule. You could give that away every month, and then it would go away because that month penalty divisor would just kick in and erase that penalty. You can't do that anymore because the penalty, they changed the rule so the penalty cannot start until you've given everything away or gotten rid of everything. So the penalty divisor is $9,600, so $170,000 gift, house or something, cost you 17.7 months of no Medicaid. So you got to be down to nothing. Then you have to be without Medicaid for 17.7 months, 18 months. And then you can go on Medicaid. So that leaves people between a rock and a hard place because you got no money, but you need care. What can you do? Well, your kids can spend the money on your care, but then the gift is gone, right? Doesn't help. So the 5-year look-back period is important to understand. If you give away any gifts within 5 years of applying for Medicaid, so the Medicaid application is the end of the 5-year period, and then you look back. So you can adjust that 5-year period if you can wait to apply for Medicaid. As that 5-year period goes on, your gifts drop off the end. So if you gave your house away 4 years ago, it's best for you to try to find a way to make it another year before you apply for Medicaid. That way the gift falls off the end and it's not counted against you. So the 5-year look-back period is very important. So what happens if you just give stuff to your kids? So I advocate usually giving things into a trust. But some people just say, I'm going to give it to the kids outright. That way I won't lose it. What are the problems with that? Well, if the child dies and you were kind of hoping that those assets would be there for you if you need it sometime in the future, well, those assets can disappear because they'll go to the child's spouse who might get remarried, or it might go to the child's kids, and then they don't know what to do with it because they're young and you can't get it back. It's not there for your security. It's going to go into UTMA or UGMA account, if you know what that is. It's just an account for a young person to hold assets, and it can't be used for anything else. Problems, of course, if the child divorces. So if you give your house to your child and then they divorce, now that house, yours, that you're still living in, is going to be messed up in the divorce. If the child has their own medical issues or bankruptcy, your house now is theirs. It's going to get taken or put liens on, or something's going to happen if something happens to your child. The biggest problem, though, that I see is the capital gains tax problem. All these problems rely on something bad happening to your kid. We never want that, but it can happen. This one is sure to happen. So, especially if you give away real estate. So let's imagine that you or your parents bought a house in the 80s for $70,000. Let's make it easy, $50,000. Then you live in the house, you keep it, but then you give it away because of you don't want to lose it in Medicaid. You give it away. Now the kids own it. When you die, it's worth $550,000. There's a $500,000 capital gain problem. Now, when your kids go to sell that house after you die, they're going to have to pay about 20 to 30%, depending on their tax status, in capital gains on the gains. So 20% of 500,000, what is that? $100,000. That's a capital gains tax problem that your kids can avoid if you plan with the trust. Because when you give something during your life, the person that gets it inherits your basis in the property. Your basis is the $50,000 that you paid for the property. And then, of course, the sale price is the sale price, and the difference is the gain, capital gains. And the government wants their tax on that. So, I've already talked about the tax issue. So, if you gift to a trust, it has to be irrevocable, and it has to be written in a certain way that it qualifies as not your asset. It won't count against you. You still have the 5-year look-back period. We call these trusts MAPT, by the way, Medicaid Asset Protection Trust. The assets then are sitting in the trust. You can still live in the house, though the trust owns it. You owe the taxes. You still have to pay the taxes, but you also get the tax benefits. So if you can deduct mortgage interest, or if you can deduct the local taxes on your federal return, etc., all the taxes pass through to you, but the ownership is away from you. It doesn't belong to you as far as the law is concerned. Yes, ma'am.
Can you put rental properties in a trust?
So the question is, can you put rental properties in a trust? The answer is yes. You can put any assets in a trust except for qualified retirement accounts. So no IRAs, no 401ks, no 403bs, none of that. That has to be owned by a person. So you can't protect those in this way. It's a big issue that we have in protecting those assets. In order to protect assets like 401k or IRA, we have to cash it in and pay all the taxes, the income taxes, and then we can protect it. But rental properties can be put in a trust, just about anything. And the nice thing about if you get one of these that's drafted properly, is you get the step up in basis at death. Now, the trust, I want to emphasize this, is not every trust that you're going to see out here that people might use to try to do this. I see trusts that people have created that don't get the step up in basis. There's always a trade-off. We put language into the trust that brings all of the assets of the trust into your estate for tax purposes. So now, if you have more than several $1 million, it's all going to come back to you, and you have to pay the estate tax. This is one of the reasons why millionaires and billionaires don't do this, because they don't want to pay the estate tax. For the majority of us, $13.61 million is more than we're ever going to pass on so we don't have to worry about the estate tax. So we have all these assets, maybe 500, 600,000 come back into our estate by thereby gaining the step up in basis. Property that's in your estate at your date of death gets a step up in basis to the fair market value. That's why it doesn't work if you've given it away during your lifetime to your kids. That does not get the step up because you did not own it at your death for tax purposes. So, comes back into your estate for tax purposes, gets the step up in basis. Now the kids sell it. They don't have to pay $100,000 in taxes on the house that you just gave them. This is way better. Yes?
Can you put an LLC in a trust?
Yes. Yes. The question is, can you put an LLC in a trust? The answer is yes. You can put a corporation in a trust. You can put patents and trademarks in a trust. You can put all these things in a trust unless those properties are part of an IRA. Yes.
If the houses, the rental properties are in an LLC, that's considered business, which would be separate from my own personal property. So does that count as a divestment? For me personally, if it's owned by the LLC.
So who owns the LLC? That's the question. Right. So if it's your LLC and you put it in the trust, yes, it's a divestment.
But it's not, because it's business assets, it's not counted as an asset against Medicaid,
It is.
but it would still.
So unless it's your house or your car or your personal things within the house, it's going to count as an asset. So if you own a business, your business is worth $100,000, they will insist that you sell the business and use that money to pay for your care before you can qualify for Medicaid.
Does that count even for MAP?
There are some exceptions if you can convince them that the income is worth it. So if they see income coming from your business that can offset the cost of your care, then it's something that you have to ask for a hearing on. So when you apply for Medicaid, you say, I want to keep this business property or this income producing property because it benefits me and it benefits the state. Because
They approved it, I think 6 months ago, but then they recently just denied it. So it depends on who you talk to there,
yeah,
I guess.
exactly. It does. It depends. It depends on who you talk to at the state. A lot of people now are getting denied Medicaid that were on Medicaid before because they're going through all the backlog because they were not allowed to kick anybody off of Medicaid during COVID. And then the COVID emergency went away and they've been going through the inventories and they're essentially kicking people off that during the COVID period either gained assets or now the rules are different or somebody is looking at it differently than they did when they first approved it. So with Medicaid, they do look at your assets every year, except for during COVID when everybody got a free pass. So some people are getting kicked off of Medicaid and it's not fair, but now you got to work the system again almost as though you're applying again. All right, so if you use an irrevocable trust, as long as it's the right kind of irrevocable trust and it's got the right provisions in there, you get all of these benefits. Now, you can get it back if needed. This depends on the person that you put in charge. This does not have anything to do with the trust, a little bit to do with the trust, but it has to do with the trustee that you choose. Most people put their children in charge. Grown children, obviously. Because
one person, or can it be all three? Cool.
Yep, you can have co-trustees. Right. We'll just say trustee, but it can be multiple trustees. As long as they work with you and you say, hey, we want to undo that, or we want to get a certain amount out of the trust, then as long as they work with you, you can get it. There's a back door to these trusts. But if they turn on you, then you're out of luck.
And the operative word is irrevocable. If it were a revocable,
then everything is available.
totally, but we're talking about irrevocable.
Right. So a difference between revocable and irrevocable is a huge difference regarding Medicaid. Revocable trust holding assets, none of them are exempt. Right? They're all counted, and it's just like you own them yourself. So you have to spend everything that's in a revocable trust, except for the house, the car, and $2,000. All right, so we do pre-planning, we do crisis planning in our firm. These are really the two types of Medicaid planning. We help people that have 5 years or believe they're going to have 5 years. Nobody knows, really. So let's talk about Dad again. If Dad did some planning, comes and talks to me and says, hey, I got this $300,000 nest egg that I've built up over my career and a nice house. It's all paid off. Say, great job, Dad. You nailed it. Okay? So now let's solidify those gains for your kids, because now it's time to look to the next generation and what happens if at the end of life you need very expensive care. So what Dad does is he says, well, I think I can be happy with a cushion of $75,000. I'll live on my income and have the $75,000 in case I need to replace the roof and the water heater and the air conditioner and take a big vacation all in 1 year. I got enough. I don't have to ask my kids or anybody else. I can just be free. Dad was happy with $75,000. He took everything else and put it into this MAPT. And now he gave over the keys, the figurative keys, to his kids, one or more of them. So now he's got this security. The kids are watching it. It's not going anywhere. They can invest the $225,000 according to whatever Dad thinks. Stocks, bonds, Bitcoin, anything can be owned by this trust. The rest of it is still available for his care. So then Dad goes into a nursing home. The $75,000 comes with him. Okay? That's all he has to spend down. This, because it's 5 years, that's important. It has to be 5 years before he goes in the nursing home. This stays here. The kids manage that and they use it for Dad's benefit if he needs anything. So during his lifetime, there's security. Unlike others who are on Medicaid, where they have nothing to fall back on. Then, if there's anything left, the children get it, right? So in this case, we've saved $525,000 for the family and provided security for Dad while he needs care. So, unfortunately, Mom did not have such a good plan. She needs a crisis plan. She did not plan 5 years before she needed nursing care because she had not come to one of these seminars. She didn't learn how important it was. So Mom came to us, or her children came to us and said, Mom needs nursing care now. And we can just foresee that all of her assets are going to disappear. Mom's got the same assets as Dad did. Now, we can do some things and end up saving the family $325,000 instead of $2,000, which is what the government's plan is. But we've got to do it quickly, and we have to separate the assets. We still use the MAPT. The MAPT is on this side this time. This 325 is just a guess. The amount that we can put in the MAPT depends on certain factors. We have to do calculations because we're going to compute a penalty period. Because this is not 5 years. This is going to create a penalty. About 33 months worth of penalty, in fact. We had to take the rest of the assets, so the home had to be sold. We take the rest of the assets and we put them in a specialized annuity, Medicaid compliant annuity. Most annuities are not Medicaid compliant. Most annuities, Medicaid would say, you need to cash that in and pay for your care. Medicaid compliant annuities have several specific rules, but one of them is cannot be sold. The rule also states that if you have an annuity, you have to provide the government with 5, or I think it was 3 letters from people whose job it is to buy annuities that say, I won't touch this thing. Okay? In order to prove that that annuity is no good. Now, I've never been asked for one of those letters because these annuities were designed to meet those rules. So nobody's going to buy them. So then you get that annuity. Now, what's the purpose of this annuity? It's to change assets from a countable asset into income. This annuity, as long as it's a properly done Medicaid compliant annuity, now is considered income, not an asset. So the person can get down to their $2,000 in their bank account where their Social Security goes into and still have a $275,000 annuity which can never be cashed in. It just pays out through the 33-month penalty period in equal amounts that just so happen, according to our calculations, to pay for the care. This annuity pays out over 33 months, the exact penalty period, in an amount just under the amount needed to pay for care. So the kids have to chip in about $100 a month in order to make this work. Now, where do they get that $100 a month? They can get it from here if they want, or they can pull it out of their pocket. So now after this annuity pays out for 33 months, it's gone. 0 left here. We paid through the penalty period. Mom goes on Medicaid because the penalty period's over. And now we still have this $325,000 that the kids are caring for. So mom still has security during her lifetime. We saved $325,000. Now it's not $525,000, but it's better than $2,000 because we did this crisis plan. Now a crisis plan does not have to be before mom goes into nursing home. We have helped people that have been in nursing home for years. The family calls up and says, I think this is the year we're going to run out of money. And I say, well, ho. Let's see what we can do. And, in different cases, we're able to save some of the money for the security and get dad, in this case, on Medicaid, or mom, so that the children can have at least something, $60,000, $70,000 for their inheritance. So, the moral is, if you don't plan, the government's got a plan for you, and it might look something like this. If you plan, you might not know where you are, but you're going to be comfortable, and you're going to have good music. You're going to live where you want to. Okay? So, please plan. If you decide you want to plan, I hope you pick the right person to plan with, and we'd love you to plan with us. Any questions? Yes, ma'am.
What if your parent, so we're kind of at the stage of the crisis plan. What if your parent is already on Medicaid, but we're now looking at having to sell the house?
Okay, that's a good question. If you're already on Medicaid and they kept the house because it was, but now the facility is telling you you need to sell the house.
So she's been living in it, so she had the 2,000 down, but it was her home, but she's went to the hospital, went to rehab, and now we're reaching that 6-month mark where it's considered long-term care.
Right.
She might be staying there.
Right. Yes, you can do a crisis plan. Essentially, save half of the house. The calculations are, you have to take in many things into that calculation. And one of them is the facility that you want your mom to move into probably requires a 24-month private pay period. Now, this is facility to facility, but most of the facilities require 24 months of private pay. I'll get to you in a second. You're next, and then you, okay.
I have a question about her situation.
Okay.
Isn't there a rule that you can give to a sibling a house, or no?
So the question is, can you give the sibling a house?
Like like in her situation, could the
If the sibling has been living with you in the house for 2 years and the doctor will write a letter saying that because the sibling was living with you, they delayed your entry into a facility. You have to meet those requirements, and then you can give the house to the sibling after you're on Medicaid. But you also have to move directly from the house into a licensed nursing facility. Can't be, um, uh, what is it? Assisted living. Can't be assisted living. It has to be directly from the house to a licensed nursing facility. There can be a hospital in between, okay? But it has to be a licensed nursing facility. It can be a sibling or a child. Unfortunately and heartbreakingly, it cannot be a grandchild. I've run into that before. Grandchildren are not allowed. Sibling or a child has lived with, and it has to be 2 years at least, in the same house with the person. And you have to get the letter from the doctor. You have to prove that they were living there first. I don't know, bills. But usually what we do is we have the doctor, because the person a lot of times goes to the doctor with the other person. The doctor can write the letter saying, I know that they were living together. This person was helping them, living in the same house, and it delayed their entry into a facility. Now, the delay doesn't have to be more than a second. It just has to be delay, right? Maybe you had to wait for them to get their shoes on before you could go out the door, right? So it delayed their entry into the facility. That's, it's all very technical. Just like a grandchild can't have it, tying your shoes is going to get you in. You don't want the doctor to write that in the letter. The doctor would just say delay the entry into the facility. So if a child has been living with that person, then there is a loophole as long as they go from the house to a licensed nursing facility. Otherwise, if she needs to sell the house, essentially you probably can save half of the assets and use the other half to pay through the penalty period.
Even if there's already an outstanding Medicaid bill.
Yep.
And, and how do you find
She'd
out?
be knocked off of Medicaid for the penalty period, right? And so she'd be private pay and then you'd have to reapply for Medicaid. Okay, ma'am?
How do you advise individuals that have substantial 401ks? Because what you're saying is that's going to be, one is going to have to use that to become broke. So is that just kind of almost good news that you do have that buffer? But how would we plan ahead strategically?
Normally, depending on whether you're married or not, Wisconsin, every state is different. Wisconsin law concerning qualified retirement accounts says that the spouse that does not need care, their retirement accounts can be exempted from counting. Okay? The spouse, right? The person, and it depends on who needs care, right? The person that needs care, that's all countable. All of their IRAs, et cetera, are countable. But there are things that I can do, I can help people do if you have a crisis situation and you have a spouse and only one of you needs care. We can save everything except for the taxes when we cash in their IRA and my fee. Everything else we can save for the spouse that doesn't need care. Now, if that spouse needs care in the future, none of that's protected at that point. But we can protect everything when normally you'd have to spend down to sometimes $50,000 for the spouse to keep, and up to $154,000, depends on what you start with, actually. Did that answer your question? So, okay. So what I tell people is if they have substantial 401ks and they think it's a high risk that they're going to need care, cash it in now and start saving, start protecting it. But for most people, you just keep it until there's a crisis. And at that point, you cash it in, you save as much as you can through a crisis plan. But in the meantime, you can put the house, your property up north, some of your investments in MAPT and wait for the 5 years, because then you'll be able to save all of that and then just half of what you've left out. Okay? Oh, you just had,
That was just a question.
okay. Yes, sir.
So in that situation, the spouse who isn't under care can have their qualified assets protected. What if it's not a qualified asset, but it's just in that individual spouse's name?
There's no, Wisconsin does not distinguish between who owns what except for IRAs or 401ks. So
LLC as well?
everything. All assets of both spouses are counted except for the IRA, which is an exception.
That's horrifying.
This whole thing is horrifying.
In care, they're asking you to be completely broke for both people in order to get your spouse care.
Well, no, not completely broke, but they do let the, what we call the community spouse, which is the spouse that still lives in the community at home, and the nursing home spouse or the needy spouse, because they might still be at home. The needy spouse and the community spouse. So if you have a couple situation, the community spouse resource allowance is what we allow the community spouse to have as resource, and it's maxed out at $154,000. That goes up according to inflation every year, but it may be as low as $50,000 depending on what you start with. So the rule is you can keep half of what you started with a maximum of $154,000 for the community spouse and a minimum of $50,000. So if you start with $70,000, and this all gets a little complicated, but if you start with 70, you're allowed to keep 50 because half of 70 is below 50, so you can keep. If you start with 45,000, you keep it all. If you start with 100,000, you keep 50. If you start with 200,000, you keep 100,000. If you start with 400,000, you can only keep 154 because half of it's too high.
Are you plenty confused now? Yeah. It is very confusing, and the good news is that you don't have to understand it. You just have to believe that he does. And as you can see by the number of questions, every situation is a little different, right? It all has its nuances. We've got this much money in this type of asset, and this much money in real estate, and this much. And so what we do is get it all down and break it down. And Dan, at the first meeting, at the first consultation, will get all this, the necessary information, and tell you what can be saved. And so, as I said, each situation is a little different. Angela and I will be making consultation appointments today. The initial consultation is in person. It's $505. And if you move forward with either a pre-plan or a crisis plan with our firm, that $505 that you pay for the initial consult is credited to the total cost of the plan. So that's how that works. My email address is laura.hamdan, HAMDAN, @friendly.law. And I'm going to email each and every one of you here because we took your names down. I know what your email addresses are because you registered to be here. And I'm going to send you a gift. I'm going to send you a list of Wisconsin community-based residential facilities and whether they accept Medicaid or not. So you can look and you can sort this by the area in which you live, where your family member that needs care lives, and so forth. So you can take a look at that, and that'll be a gift for you. If you book your consultation before you leave today, you also get a fabulous hat and keychain. So Angela and I will be out here ready to make those consultation appointments if you like. Thank you so much, Dan. You really, it's amazing.
Thanks, Laura.
Mm-hmm.
So, as a reminder, if you like the book, please take it with you, but leave $10 on your way out. Otherwise, if you think next week you want one of them, they're on Amazon. I think they're $15 on Amazon. You might have to pay shipping. I don't know if there's free shipping on these books. Anyways, thank you so much. I do appreciate your attention, And I hope that all of you have your own plan and don't rely on the government's plan because it usually is not the best plan for your family. Yeah, sooner is better than later with a 5-year look back period.
We spent the weekend with, we had all of our kids from out of town, taking them family by family and said, what do you even, like, we have a cabin. It's like, how do you foresee that cabin? Like co-owning it, renting it out? You know, we had no idea. We had different responses from everybody. And it was like, well, that was very eye-opener, you know, to hear what their ideas were. Two of them, we said, we don't want to sell your house because we built our house. And, you know, it's like, well, what would you do? Like, how do you know who gets